There are two different mental health standards that apply in Colorado. And one of them is a defense that you can use at trial, and that's the defense of not guilty by reason of insanity. There's another time that mental health will come up, and that's in competency proceedings that happen while a case is pending, but it's not actually a defense that occurs at trial. If you, at the time a crime is committed, if at that time, because of either a mental disease or defect, you were incapable of appraising your conduct to what an ordinary person would do, you didn't understand the difference between good and evil, and you weren't capable of appraising your conduct to the law because of that mental disease or defect, then that's when a lawyer can raise a defense of not guilty of the charge by reason of insanity. It's not a defense to the extent that if you succeed at trial, you're released, right? So typically, if you plead not guilty to a charge, right, and you go to trial and the jury agrees that the DA hasn't, proven each and every element of the defense beyond a reasonable doubt to the extent to convict you of that charge and find you guilty, then the jury finds you not guilty, you're released, the charges against you are dismissed, you go back to your life, or if you're convicted of lesser charge, you deal with that. But at any rate, if you're found not guilty of a specific charge, that no longer has any bearing on you, right? But it's a little bit different if you plead not guilty by reason of insanity, because even if you succeed and convince those 12 members of the jury that you didn't commit the crime because you weren't capable of appraising your conduct to the law, then at the end, you won't face any criminal penalties, but you will still be committed to the Department of Health so that they can restore you to sanity if possible. That commitment can be indefinite. And that's a pretty big analysis that, a lot of times defense attorneys will run into, where if you've got a client that's facing maybe a felony charge, or certainly any misdemeanor charge, if you plead not guilty by reason of insanity to that, then your period of commitment at the Department of Health, the Mental Health Institute in Colorado, your commitment there can be indefinite, while the charge themselves can only have a specific period of maximum incarceration. So, a misdemeanor case typically carries less than a year in jail. Well, if you're convicted of a misdemeanor case in the ordinary standard, then a judge can't sentence you to more than a year in jail. But if you're found not guilty by reason of insanity, you could be committed for an indefinite period of time until and unless you're restored to sanity. That's why you see people pleading not guilty by reason of insanity a lot more to charges like murder, which carries in Colorado a maximum period of incarceration of life without the possibility of parole, actually a mandatory period of incarceration if you're convicted of first-degree homicide, which is a lot different than some other charges where it may not be worth pleading that defense even if it is applicable. Competency, on the other hand, is different. So what competency means is, do you understand the charges against you, their possible penalties, the court proceedings, and are you able to assist your attorney in developing a defense for you? So competency is about the process rather than the actual merits of the case itself. So you see this a lot of times where somebody who may have been sane at the time that the alleged event occurred is then later, while the case is going through the pretrial proceedings, found to be incompetent, right? And so what that means is, all right, well, there wasn't this issue with them being able to praise their conduct to the standard of the law at the time they allegedly committed the crime, but because something has happened since then, or maybe this existed all along, they can't understand the court process, they can't help their lawyer prepare their defense. And so what the law says is, at that point, you can't take them to trial because it wouldn't be fair. In that situation, what will happen is somebody will raise competency. A lot of times it's the person's own attorney, because we're the person that's having direct involvement with them. Sometimes their lack of competency is so overt that even a judge will notice it during the limited periods of time that a judge gets to see that person. But at any rate, once competency is raised, then the person is sent for a competency evaluation at the state hospital, and the person that's doing the mental health treatment at the state hospital will put them through a battery of tests to see if they understand those things. If they're deemed competent, then great, the case goes back to its normal proceedings. If they're deemed incompetent, then they have to undergo what's called competency restoration, where some person at the state hospital will try and get them on treatment or medication or whatever's necessary to help them understand the process and restore them to competency. Once that happens, then the case is able to resume. The other important part about competency is that even if you've pled not guilty to a charge, and that's where the 6-month speedy trial right in Colorado starts, if competency arises during that period of time, then that clock doesn't continue to tick. It's told while competency is evaluated, meaning that we won't continue running that clock. We'll put it on pause while somebody goes to the state hospital to undergo that evaluation. So that's really the fundamental difference between insanity and competency in Colorado.